in Sioux City, and is married, as this gentleman supposed to know, is married to Birkenpass from Sioux Center. I couldn't find a Sioux Center girl, but I did find a Van Dyke to marry. She hasn't quite made the full transition to be a Norwegian yet, but my family is originally from just across the river over there in Deersford. So I stopped there to visit the cemetery, it'll be a future residence for me. Just trying to get to know my neighbors there a little bit better. But anyway, it's just wonderful to be with you. By the way, Leon, hi, come on in. Leon is still doing well. I had breakfast with her this morning. Bob, my brother in Sioux City, attorney in Sioux City, is suffering from Alzheimer's now and will have his 88th birthday next week. And anyway, so we're going to be having a celebration for both of them because it's also their 60th wedding anniversary. An anniversary that I remember very well because it took place in one of the churches right here in Sioux Center. And I've been back a number of times since. But when Jacob and I were talking about a topic, one of the things that we considered was something dealing with the abortion issue, because even though that's been a perpetual issue for a long time, it seems to be an especially hot issue today. And I sense the mood of people who are pro-life to be much more optimistic right now than it has been for a long time. And part of that has to do with some changes in public attitude. Part of it has to do with the number of states that are stepping forward, but much of it has to do with a change in the Supreme Court. And I'm going to talk about that in a little bit, but as you can see from the outline here, I'm going to talk about why that Roe versus Wade decision is wrong, and why it is wrong, first of all, biblically, and second, morally, third, medically, and fourth, constitutionally. And then where we're going with it today, what's happening in other states as well as here in Iowa, and what might be the prospect of actually ending Roe versus Wade and returning this matter to the states. We had a bill passed in Iowa this past legislative term. It goes further than any of the bills in other states because ours protects human life and makes abortion illegal anytime from conception on. And anyway, so part of our campaign for this was we're talking about states' rights and we're talking about civil rights both. We're talking about the civil right of the unborn child, the right to life, but we're also talking about the right of the states, particularly the state legislatures, to make laws in this area, a right that was taken from them by Roe versus Wade when they struck down the laws of almost every state in the country back in 1973. And so our goal is to protect the civil rights of the unborn child, but also to protect the right of the state of Iowa, the state of Alabama, and other states to regulate in this area as they see fit. But let's begin with this question about why Roe versus Wade is wrong biblically. And I say that because for many of us, we believe the Bible to be the inspired Word of God. For those who may not share that belief, and by the way, I'm going to get the basic statute book here, but for those who don't believe that, at least they would recognize that the Bible has been a formative influence on American law, and it should be looked at for that purpose. But I could begin by simply saying that the Bible prohibits abortion, and I point to my text that says, "Thou shalt not have an abortion," except I haven't been able to find that one lately. Nevertheless, the commandment says, "Thou shalt not kill," or some translations would render that, "Thou shalt not murder." But is taking the life of an unborn child murder? That's going to depend on whether the unborn child is a person. And so there I can point to the text in Hezekiah that says, "Life beginneth at conception." That's the King James Version of the book of Hezekiah. Unfortunately, the book of Hezekiah never existed that I know of, and it's never made its way into the canon of Scripture. But taking Scripture as a whole, I think we can say that it points strongly to the conclusion that life does begin at conception. The first point I make, if you're following the outline, would be that if you look to the languages of the Bible, they make no distinction between a child in the womb and a child that is already born. For example, in the book of Luke, we see one of the Greek words that is used for child, the word brephos, and that's the word you commonly use for a tiny baby. But the word brephos, we see where Elizabeth, the mother of John the Baptist, when she comes into the presence of Mary, the mother of Jesus, she says, "The babe in my womb leaped for joy." The word is brephos. Not the fetus in my womb, not the fertilized egg in my womb, not the unborn tissue in my womb, but the babe in my womb leaped for joy. And then later in the next chapter in Luke, we read where the angel says to the shepherds, "Thou shalt find the babe wrapped in swaddling clothes, lying in a manger." There we're talking about a baby that is already born, and same word, brephos. And then in Timothy, Paul says, "From a child thou hast known the Holy Scriptures, that is able to make thee wise unto salvation." I get into a lot of theological issues of baptism and things like that with that verse, but I won't. But at any rate, there we're talking about probably somebody that's well beyond birth. And yet Paul says, "From a brephos, from a child, thou hast known the Holy Scriptures." Another word, the word weos, is the word for son, and that thy cousin Elizabeth hath also conceived a weos, or a son. Not she's conceived a fertilized egg or an embryo, but a son. And Jesus is told there when he's a young adult that the Father speaks to him at the baptism by John the Baptist and says, "Thou art my beloved weos," or son. Same word for a child that is born, a child who has already become a young adult, or in the other passage there under weos, where thou shalt conceive and bring forth the son. Again, two verbs, conceive and bring forth, same direct object, weos, or son. And then the word beneh, the Hebrew word that is used for son, we see that when we're talking about Jacob and Esau, that the sons struggled together within their mother's womb. And word there that is used for son and used elsewhere in the Old Testament for a child that is already born, and sometimes even for an adult son. Another point that I'd make here is simply that the biblical authors identify themselves with the unborn child. David says in Psalm 139, "Thou hast covered me in my mother's womb." Not the fetus that became me, but me. And Isaiah says, "Thou hast called me from the womb." Whatever that was in the womb, Jeremiah has a similar passage, whatever that was in the womb, as far as these biblical authors are concerned, that is me. The Bible speaks about the unborn child dying, when Job speaks about how he wished that he could have been carried from the womb to the grave and would have been as though he had not been, and so on. And you can't die if you're not alive. That certainly speaks to the fact that that unborn child is living. Now another, and this is one that I consider to be a very important passage, although it isn't used very often because it is misinterpreted sometimes, and in a few instances I think it has also been mistranslated, but the Bible provides legal protection for the unborn child. And we see this in Exodus 21, verses 22 through 25, or 22 through 25, that's right. I'll just read the passage for you here. "If men strive and hurt a woman with child so that her fruit depart from her, and yet no mischief follow, he shall be surely punished according as the woman's husband will lay upon him, and he shall pay as the judges determine. And if any mischief follow, then shalt thou give life for life, eye for eye, tooth for tooth, and so on." Now, as I say, this is not used very often because it is often misinterpreted, and occasionally it has been mistranslated to say, where you read the words in the King James, "so that her fruit depart from her," or in other translations, so that she gives birth prematurely, or several say so that her children come out from her. But several have translated that so that she has a miscarriage. The first edition of the New American Standard translated it that way. They have corrected that in later editions of the New American Standard. And I have to say the New American Standard is very accurate on the New Testament Greek, perhaps a little less so on the Old Testament Hebrew, but they corrected that anyway. And anyway, that's not really talking about a miscarriage. I'd point out a couple things about that. First of all, that the word there, yeled, for fruit or child, so that her child or her fruit depart from her, really the King James is about as literal as you can be in the translation of this particular passage. But we find that word in the Old Testament 89 times. And everywhere where it is used in connection with childbirth, it is used for a normal childbirth. Likewise, the word for come out, the word yatsah, depart, fruit depart from her. Again, everywhere where that word is used in reference to childbirth, it refers to a normal childbirth, with one exception in Numbers where it might refer to a miscarriage, or it might refer to a stillbirth, but even there, not a miscarriage. And if Moses wanted to speak about a miscarriage, there are other Hebrew words that he could have used for miscarriage, but he didn't use those here. And I'm convinced Moses, writing under the inspiration of the Holy Spirit, said what he meant and meant what he said. The Bible also speaks about the unborn child as having a sinful nature, and this to me is a very important passage when David says in Psalm 51, "Behold, I was shapen in iniquity, and in sin did my mother conceive me." Now you think about that a minute. He's not saying there's anything sinful about the act of conception. He is saying that he had a sinful nature from conception. Having a sinful nature has to imply personhood. You can't have a sinful nature, I don't think, unless you're a person. So that brings personhood not only back to before birth, it brings it all the way back to the point of conception itself. And then we see the personality of the unborn child as John the Baptist leaps for joy in his mother's womb, as Jacob and Esau strive together within their mother's womb and show characteristics that are going to follow them throughout most of their adult lives. Putting all this together, I think it points strongly to the conclusion that, according to the Bible, life begins at conception, and the unborn child is a living human being. Now, there's one verse that some will use to try to draw the opposite conclusion, and that's where we read in Genesis that God breathed into man the breath of life, and man became a living soul. And the suggestion is made that you're not really a fully human soul until you take that first breath. Well, the problem with that is Adam was never an unborn child. Adam was never a baby. Adam was formed as an adult, mature human being. And not only that, but Adam was formed out of inorganic matter, the dust of the ground, and I don't think that applies to any of us. So you don't read anywhere else in Scripture where God breathed into anyone else the breath of life. That is Adam and Adam alone. Even Eve is formed out of Adam's rib, and we don't read that God had to breathe the breath of life into even Eve. So this is not normative as to the way human beings began. If any of you were formed directly out of the dust of the ground, then maybe we'll have to talk about an exception, but I haven't found anybody like that yet. Luther put it this way: the begetting of children is wonderfully pleasing to God. How great, therefore, the wickedness of human nature is. How many girls there are who prevent conception and kill and expel tender fetuses. And John Calvin, I think, was even more specific about this. Calvin says, if it seems more horrible to kill a man in his own house than in a field, because a man's house is the place of most secure refuge, it ought surely to be deemed more atrocious to destroy a fetus in the womb before it has come to light. In other words, he's saying, if a murder seems to be a more heinous crime if it's committed in the sanctity of one's home than, say, out in the streets, well, the most sanctified place for a baby is in the mother's womb. And so it should be more horrible that a child is killed in the mother's womb than somewhere else. Again, putting all this together, I think it points to the conclusion that life begins at conception. And not only is that the Catholic tradition, but it is the Protestant tradition as well. Let's move on to the moral issue. And as we look to the issue of morality on abortion, I guess the question still has to arise, even if we concede that that unborn child is a living person, is it ever right to kill that person? After all, the Bible prohibits murder, and all killing, or rather all murder is killing, but all killing is not necessarily murder. When the Bible speaks about killing in war or executions, it uses other terms than the term rot sock that it uses for murder in the command, thou shalt not kill. Several of the arguments that are raised to justify it are, number one, freedom to choose. And that rings a bell with me, because I'm one who thinks the government tends to get into regulating our lives a lot more than it should as it is. But nevertheless, a basic function of government, even if you take a strict libertarian standpoint, a basic function of government is the protection of human life. And if we're going to protect human life, we have to make a decision as to at what point we're going to begin that protection and at what point that protection is going to end. It would seem to me that the most sensible place at which to begin that point of protection would be the point at which life begins, the point of conception. And when we're talking about this being my body, well, that unborn child is not part of the mother's body. We'll talk about the medical aspect in just a little bit here, but the fact of the matter is there is about a 50% chance that that unborn child could be male, in which case obviously that child is not part of the mother's body. What about abortion for birth defects? And that's been a justification that many have raised over the years. A couple of the arguments that I've raised in regard to that are, number one, we don't really know for sure in many cases whether a child is going to have a defect or not. And if we do know, we don't know how severe that defect is going to be. And so if we're going to say that you can have abortion in case of birth defects, maybe we should really wait until after the child is born and examine the child and see the defect and then make a decision. Amazingly, there are some who would take that pretty seriously today. But even then, we may not know how severe it is, so maybe we should wait till age 3 or age 10 or age 75 or somewhere in there. Point of the matter is, and I'm being facetious when I say all this, but the point of the matter is that any argument that can be made for abortion because of birth defects can be made just as strongly for abortion or for infanticide because of birth defects. The fact is that many of those who may have birth defects may turn out to live very meaningful lives and very happy lives, may make great contributions. And in fact, in our state guard, we had a funeral for the special needs child of one of our members recently, and the guardsman himself, who was a strong believer, had what he said at the funeral, that God gives us normal children so that we can teach them. He gives us special needs children so that they can teach us. And the things we learn from them, the types of contributions they make to the world, can be very, very remarkable. And when we talk about meaningful life, whose place is it really to decide whose life is meaningful and whose life is not? That ultimately is the decision of God. What about for emotional harm? The problem with saying that there should be abortion because of emotional harm, first of all, it is weighing two rights. One, the right of the child to life itself, versus two, the right of the mother to be free from emotional harm. And I would have to say that balancing those, the right of the child to life has to take precedence. However, it isn't really that much of a dilemma, because normally abortion is not going to solve the emotional harm. Rather, emotional harm is simply going to be complicated by an abortion. It adds another trauma. It adds many times guilt, many other factors, not only for the mother, but for many others that could be involved as well. Rape or incest. Now this becomes a difficult issue. And I want to begin by saying that it is a very, very serious issue for those who are affected by it. However, we're actually talking about less than 1% of all abortions here. And so it should be an exception narrowly drawn out for that 1%. It shouldn't be a basis for abortion on demand. But should it apply in that circumstance? Does abortion solve the trauma that results here? And is it really just? Sometimes if I'm talking to a teenage audience, and they raise the question, as kids often do, and I'll just ask, well, suppose you came home from school one day and you're alone at home. There's a knock on the door, and the police officer saying, I'm taking you to jail, you're under arrest. Well, why? Because your father just robbed a bank. What question is going to come to your mind immediately at that point? Not fair, why not?
I didn't do anything wrong.
Why should I be punished because of something my father did? Why should that unborn child suffer the death penalty because of something his father did, or in the case of incest, the father and mother both may have done? And so again, I wouldn't say that is a justification for abortion. Adoption might be a better solution, and probably is a solution in most instances, although I have known mothers who have conceived and raped and have raised those children and have been very thankful that they have done so. What about for unwanted and abused children? Well, I used to serve in juvenile court in Woodbury County here in Iowa before I went into the Air Force, and we had a lot of juvenile court cases there that would involve child abuse. I don't recall we ever said, well, you've really had a rough life, kid. We're going to take you in the back and we're going to give you an injection and it'll be all over. No, we don't kill children because they're being abused after they're born. Why should we do so before they're born? And in fact, studies show that it is very difficult to predict that based on whether a child is wanted at conception or wanted at birth, as to whether a child is going to be abused later in life. And many times attitudes change quite dramatically during that period of time. And then the final justification, the life of the mother. What is the situation where the mother's life is in jeopardy if she is forced to go through with this childbirth? In that circumstance, I would say that the law should allow an exception. I've known of mothers who have said, including my wife, who has said, although she was never faced with the situation, thank God, but who have said that if I were in that situation where my life were in jeopardy, I would not have an abortion. I would choose to go through with the childbirth and leave the consequences to God. I respect that. I wouldn't say that has to be a legal requirement. Well, one time I was speaking in mountains in southeastern Oklahoma on this issue, and right about this time, I had a man who was at a camp, and had a man come up to the microphone and said he wanted to say something, and something in my mind said maybe I should let him talk. He was bigger than I was. But anyway, he said, well, I just want to tell you something about this. My mother was told that if she ever became pregnant again, it would kill her. And she became pregnant again. And the doctors begged her to have abortion, and she absolutely refused, and I am thankful that she did because I am her youngest son. And I couldn't have done it better than that. But let's look at the medical issues then. And first of all, one of the reasons for looking at this is when we talk about there being two kingdoms, church and state, and we talk about how God has given us the gift of revelation and the gift of reason, He's given both with a purpose. And I think it's entirely appropriate as Christians that we make up our mind on this issue based on what the Scripture says. But if we have to go to a precinct caucus or a county convention or testify before the legislature or be involved in the public arena, we need to be prepared there to defend our conviction based upon reason and evidence. I'm not saying that Scripture has no place there, but I'm saying that when we're dealing with people who may not consider themselves covered by Scripture, we have to be prepared to defend our position on reason and evidence. First of all, from the very moment of conception, that child has a genetic makeup, a DNA, that is entirely the child's own. Different from the mother's, different from the father's, different from anyone ever to live on the face of the earth, with the exception of an identical twin. And that genetic makeup is going to determine, to a large extent, the child, well, it's going to determine definitely the child's race and sex. To a large extent, it will have an influence on bone structure, muscle structure, on color of eyes, and mental development, many things like this. All of that is set right from the moment of conception. You have that DNA that is distinct to that child. Second, 2 weeks after conception, the child has its own blood type and its own blood supply, a blood supply that comes in contact with the mother's blood supply through a membrane, but does not commingle with it. By the end of the third week, 21 days, the child's heart is beating, and a body rhythm has been established at this point. The heartbeat can be detected on an electrocardiogram at the end of the fourth week, 28 days, and also by that time, the arms and legs and kidneys, liver, and digestive tract have been formed. By the end of the 8th week, that's the end of the second month, child is about the size of a thumb. But all the organs and appendages have been formed. The child even has distinct fingerprints at that point. By the end of the 12th week, the palms are sensitive. The child will grasp an object if it's placed in the womb. The child can make a fist, swallow, lips part. Its brow will furrow, its eyelids squint. We believe that child can feel pain. There are some who will try to dispute this, but I think they're just trying to deny the obvious there. That's by the end of what we call the first trimester. All that establishes then that this unborn child is in fact a person, and as a person should be entitled to the rights of personhood. Well, we talked about Roe versus Wade, the abortion decision being wrong biblically, being wrong morally, being wrong medically. Now let's talk about the Constitution. Despite what I've just said, back in 1973, the United States Supreme Court issued the Roe versus Wade decision, a 7-2 decision, in which they said that there is a constitutional right to abortion, and therefore the abortion laws of Texas and of almost every other state in the country were therefore unconstitutional. This took the matter away from the state legislatures and said that from now on, this is a matter that will be decided by the federal courts. It was a 7-2 decision. Justice Rehnquist wrote a dissenting opinion, as did Justice Byron White, but nevertheless, that decision stood and partly still stands today. But I'm going to suggest that I think that decision was wrong in a number of ways. First of all, because there is no right to abortion mentioned anywhere in the Constitution. Closest they can come to it is to say that there is a right of privacy, except that right of privacy is not mentioned in the Constitution either. And so they say, well, that's found in the term liberty as we see it in the 14th Amendment. And Justice Blackmun, the author of that opinion, essentially what he says is certain rights in the Constitution have emanations that form penumbras. Now, those are a couple of big words, but penumbra means an aura or a shadow. And essentially he's saying that as he reads the Constitution, apparently he has a special set of colored glasses to read it with, but as he reads the Constitution, he sees these emanations flowing out of it and then coalescing in the margins or between the paragraphs, and there he sees words like privacy and abortion and same-sex marriage and same-sex conduct and things like that. He sees things like that written in the margins like this. The problem with that kind of judicial interpretation is it is entirely subjective. It removes the Constitution from any kind of objective scholarship, and the Constitution then becomes anything any judge wants it to be. Thomas Jefferson once warned about that He said that he thought the seeds of dissolution of the federal republic would lay in the federal judiciary. And he talked about these judges and how they're just as political and just as human as everybody else. And he says, in the hands of judges like that, the Constitution would be nothing but a ball of wax. I was like that exchange in Lewis Carroll's Through the Looking Glass when Humpty Dumpty says, when I use a word, it means exactly what I want it to mean, nothing more and nothing less. And Alice says, the question is, can you make words mean different things? And Humpty Dumpty says, the question is, who is to be master, that is all. And I don't know if Lewis Carroll had the Supreme Court in mind when he was saying that, but he is right. If judges are free to make the words of the Constitution mean whatever they want them to mean, then they have become masters. And that's not the kind of constitutional republic our founders left us. And I don't think it's the kind of government that most of us want today, government by a judiciary. A second problem is his decision uses viability as the test point at which a state interest becomes compelling. Viability means the point at which a child is able to survive outside the womb. Now, I'm not sure when the child is able to survive outside the womb. I got a call from my 30-year-old son who has a doctorate in physical therapy and is a very successful physical therapist, but with all kinds of finance questions and so on. In fact, until this year, I think he believed the Easter Bunny did his taxes for him, but I'm not sure he's viable. But when is a child able to survive outside the womb? Well, Justice Blackmun said in that decision that it is at the end of the second trimester, that is the beginning of the 7th month of pregnancy. And from a medical standpoint, that was fairly accurate back in 1973. But no longer is that the kind of viability now. With medical science today, babies can survive after 5 months rather than 6 months, sometimes a little earlier than 5 months. And as medical science advances, the age of viability in that medical sense alone is going to be moved closer and closer to conception. Besides that, that's really a very subjective test. That is the opinion of a doctor as to whether this child could survive outside the womb. And chances are we're talking about the opinion of a doctor who tends to profit from saying the child is not viable and therefore an abortion can be performed. Anyway, that is not an appropriate test as to when a state's interest in an unborn child becomes compelling and the state can regulate in this area, but that's the way Justice Blackmun used it. Third, it wrongly regulates abortion to the status of what we call a higher level fundamental right, when the right is not even mentioned in the Constitution, let alone given that status. It also ignores the child's right to life. As I said, Justice Blackmun based this primarily on the 14th Amendment, which says, nor shall any state deprive any person of life, liberty, or property without due process of law. And there's liberty right there. Well, life first. So if that protects a right to liberty, doesn't it also protect a right to life? Blackmun's answer to that was that the framers of the 14th Amendment, when they spoke about a person, intended only people already born. That flies in the face of history. That was right at the time when medical science was showing the development of the unborn child. But anyway, that's another mistake in the opinion. And as I mentioned already, this living constitution approach, well, it's a stretch of that because, again, it leads to all kinds of what I would call judicial tyranny. But even more recent Supreme Court decisions have started to back away from Roe versus Wade. Thinking about, for example, the Planned Parenthood versus Casey decision, and that decision was 1992. In that decision, you had, as the decision was ready to be announced, pro-life people and pro-abortion people. By the way, I won't use the term pro-choice because the baby doesn't get a choice, but you had both of them lined up there in front of the Supreme Court waiting to see the decision. When the decision came down, neither side was cheering and neither side was exactly horrified either. The decision did not go so far as to overrule Roe versus Wade, although 4 justices wanted to overrule versus Wade. but rather it came down to be a very complex decision. Justice O'Connor began the decision with the words, "Liberty finds no refuge in a jurisprudence of doubt." And then, after that dramatic introduction for the rest of her opinion, she proceeds to create a jurisprudence of doubt. But essentially what she said was that we're not going to overrule Roe versus Wade, as Justice Rehnquist said in a dissenting opinion. He said, even the plurality here cannot bring itself to say abortion was, or that Roe versus Wade was correctly decided. But that after a generation has grown up to it, we're not going to overrule it, at least not yet. But she said, we are going to recognize that the state may regulate in this area in ways that we would not have recognized before. Essentially, she reduces the right from being this fundamental upper tier right to kind of somewhere in the middle, a less serious right, and the state can intervene in areas where it would not have been recognized before. For example, laws that would provide for parental notification, that would require parental consent if there's an escape clause, and laws that require that the mother be notified or informed of the status of fetal development. Other factors like this. These states can regulate in these areas so long as they don't put an undue burden. There's a big legal term, the undue burden. That becomes the test now. And anyway, so that's where we are right now. Abortion can be regulated so long as the regulation doesn't place an undue burden upon the mother's right to choose. And then a few years later, in 2007, we have Gonzalez versus Carhart, in which the Supreme Court, by a 5-4 margin, upholds as constitutional a federal law that prohibits partial birth abortion. Justice Kennedy, who has disappointed many times, but has also written some good decisions sometimes, but Justice Kennedy wrote the majority opinion supporting that law. Justice Ginsburg was extremely critical of his decision. She said that all this decision does is lay the groundwork for overruling Roe versus Wade. I hope she's right. She said, he doesn't even use proper respectful terminology. He refers to those who perform abortions as abortion doctors rather than by their proper medical terms. Well, she really wouldn't like the terms I would have used. But anyway, all of this lays the groundwork, I think, for overturning Roe versus Wade. So if you're looking at the outline, we're on page 2 here, where I'm going to suggest that we have a winnable war. First of all, the abortion rate has been declining. In the 1980s, it was about 1.6 million abortions per year. Now that's down to 1.1. That's still horrible. Still one abortion every 26 seconds, and if anybody knows when I started talking, you can figure out how many abortions have taken place in this country since I began this speech. But at least it's in the right direction. There seems to be a growing consensus among people that life does begin at conception. And well, that seemed to be an outrageous view some time ago. With the work that Right to Life people have been doing, and with the advances in medical science, that seems to be more accepted today than it was before. Now, when you look through polls on the subject, sometimes those polls are going to vary a great deal depending on how the question is asked. I saw a poll some time ago in which people were asked the question, do you believe that the decision to terminate a pregnancy should be between a mother and her doctor? 68% of people said yes, they agreed with that. Next question in the poll was, do you believe the unborn child is a living person whose life should be protected by law? 69% answered yes to that question. Obviously, you've got a large portion of there that are giving very inconsistent answers and haven't thoroughly thought that through. But the movement is in the right direction. There are a number of state laws, and this has been going on for several years, but especially in this last term of state legislatures, this last spring, we've seen a number of state laws passed that no one would even bother to introduce these a few years ago because we knew what the court would do with them. court and strike it down. Now, it seems like those who are pushing in the legislatures for pro-life laws sense that they have the possibility of victory at this time. And I certainly hope they're right. North Dakota, for example, in 2013, passed a law, the heartbeat bill they call it, and in that law provided that abortion will be prohibited any time a heartbeat can be detected. A federal court struck it down as unconstitutional. It went to the Eighth Circuit Court of Appeals, and the Foundation for Moral Law, where I serve as counsel, joined with the Lutherans for Life, where I serve on the board, to file a brief in support of the law. And we made the argument there that heartbeat is a much better test as to when the state's interest is entitled to protection than is viability. And all the subjective factors that I mentioned earlier about viability. Now, heartbeat, that's rock hard science. Either there's a heartbeat or there isn't. And so it makes much more sense to use that test. Well, the Eighth Circuit did something a little unusual. They came back with a decision in which they said the Supreme Court has said that abortion is a right up until viability, and we are bound by the Supreme Court's ruling. However, we strongly urge the Supreme Court to reconsider the viability test the next opportunity to do so. Not very often does a circuit court uphold a law and issue a ruling saying we issue this ruling because we're forced to, but we urge the higher court to overrule this and reverse us. But that's what they did in that case. And you can be sure that when the next case comes before the Supreme Court, that language is going to be quoted. We've seen other states pass fetal heartbeat bills. Missouri and Kentucky and Georgia and Mississippi and Ohio have banned abortions after a fetal heartbeat can be detected. Louisiana adopted a fetal heartbeat bill. There it says that the law will go into effect if the Supreme Court, or rather if the Fifth Circuit Court of Appeals approves the law that their neighbor Mississippi had just passed. In other words, they say, we'll let Mississippi be the test case rather than us, and we'll save ourselves a little expense here. And Iowa, of course, banned abortion after 6 weeks. And that was struck down by the Iowa courts based on the Iowa Constitution. Now, there's not a whole lot that can be done about that decision. The rule in law is that every state Supreme Court is considered to be the final interpreter of its state constitution. And the Iowa courts based their decision in this case not on the federal constitution, but on the Iowa Constitution. And so federal judges and even the U.S. Supreme Court really have to leave that alone. But what I understand you're doing right now here is you are seeking to amend the Iowa Constitution, and the proposed amendment would say that nothing in the Iowa Constitution either guarantees a right to abortion or prohibits abortion. Practical effect of that, if that becomes law, if that becomes part of your state constitution, will be that that decision by the Iowa court is effectively set aside, and the next time an abortion bill is passed by the Iowa legislature, it'll be decided based on the federal constitution, not on the Iowa Constitution. I think that's the best you're going to be able to do right now, and I certainly hope that that amendment is passed. We passed a similar amendment in Iowa back in the 2018 election. In Iowa, an amendment has to be approved by the legislature, then it goes to the voters in the next election, and voters in Iowa approved an amendment, the Sanctity of Life Amendment, that provides that nothing in the Iowa Constitution or in the Alabama Constitution guarantees a right to abortion, and goes on to say that it is the policy of the state of Alabama to protect human life at all stages of development. Now, based on that, we went ahead then this year and passed a statute that the Alabama abortion law, which is said to be the strictest in the nation, and it is in the sense that it protects the right to life all the way back to conception. We did that to make it consistent with the Alabama Constitution. The Alabama Constitution says that it is Alabama policy to protect life at all stages of development. So our law on abortion prohibits abortion at all stages of development. The law also, by the way, one of the things people have been saying is, since the law provides for a punishment of up to 99 years in jail for an abortion, this means a mother can be jailed for 99 years for having an abortion. Well, anyone who says that is either lying or they just simply haven't read the law. The law specifically says that mothers may not be prosecuted under this. And so it will apply to others who perform an abortion. But the reason for the penalty being what some think is surprisingly strong is that it's consistent with the view that life begins at conception. Why would we say that this child is a person from conception and then say, but if you abort that child, it's only going to be a $100 fine or something like that? If that child is a person, then the punishment for taking that child's life should be similar to the punishment for taking anyone else's life. Anyway, several other states have passed laws like Utah and Arkansas banning abortion after the middle of the second trimester. Several have passed pain-capable bills, and I think that's a good thing because it puts the other side in the prospect of trying to make it, either they have to say, well, we don't care if the child feels pain, or they have to argue that no, the child doesn't feel pain, in which case they fly in the face of what the vast majority of medical science is saying today, and increasingly showing that. Now, one of the reasons that they're doing this is that they sense the possibility of victory at the Supreme Court. And I'm not going to say for sure what the Supreme Court's going to do. When I do, I'm wrong about 50% of the time. By the way, I did predict the American Legion, the Cross case, I did predict that one correctly. But the 1930s. And I think the Fifth Justice is in place today, and I think a good likelihood that the court will, when the right case comes before it, overrule Roe versus Wade. If that happens, that's not going to mean that the battle is over. It means the battle goes back to the states. There's a question that's sometimes raised, well, if our state, before Roe versus Wade, had a law that prohibited abortion, and now that Roe versus Wade is overruled, is that law resurrected? Legal scholars are unsure of that. I would have to say the safest guess is probably not, and we probably have to pass a new law. But at any rate, the point I'm simply making is, yes, I think victory is within grasp at this point. And we're seeing some panicking on the other side. New York law that would legalize abortion anytime up to birth. Just in the last few days, Illinois has passed a similar law. Several other states have been passing provisions saying that it is our state, Vermont, for example, that abortion is a fundamental right in our state. They are doing this because they anticipate that they won't be able to rely on the federal courts and the federal Constitution anymore, so they better shore up their own state laws to protect abortion. The very fact that they're doing that tells us that they're beginning to see the handwriting on the wall. Well, I would urge you to stay informed on these issues, and between Jacob here and Tammy, you've got some very good people to help you keep informed. Work with pro-life organizations like the Sioux County Conservatives and Eagle Forum and Phyllis Laffey's Eagles and the others that are working in this area. And certainly keep these matters in prayer. Support crisis pregnancy centers. Make sure that we can put to lie the argument that is so often raised that, well, you pro-lifers, you're all for protecting that unborn child, but once that child is born, you don't care. Well, the fact that we're not for a socialist government to take care of everybody doesn't mean we don't care, but certainly we need to make sure that those mothers in need who opt to give birth, who opt for life, that they have the resources they need in order to put that choice in effect and carry it out. Anyway, so finally, pray in this area. As the Proverbs says, like the rivers of water, so God, or the king's heart, and king, the word melech also means judge. The king's heart is in the hand of the Lord, like the rivers of water, he turneth it, whithersoever he will. And God can influence those judges, just like he can influence those legislators. And so be in prayer for them. Do we have time for some questions?
If I may, John, thank you so much for this wealth of information. Two things. There's a push for an Article 5 convention where we see forces being willing to want to put abortion in the Constitution. If you could speak to protecting that from happening. And number two, have you been watching how the ERA people are trying to, reassert that, hey, we're only 1 or 2 away, and I'm just understanding that's because they want abortion attached to the Constitution. Do you have any, pushback ideas or thoughts?
Well, just a couple quick thoughts. First of all, this is a secondary issue, and so I'm not going to get into it too much. But first of all, on the issue of an Article 5 convention, what Sandy is talking about here is, in Article 5 of the Constitution, there are 2 means of amending the Constitution. One is the one we've used consistently 27 times, of having it passed by 2/3 of both houses of the legislature, then ratified by 3/4 of the states. The other is if 2/3 of the state legislatures call for a convention, then there will be a convention. And the convention will propose amendments, which again will go back to the states for ratification. Now, on the question as to whether we should use that second route, the idea of a new constitutional convention, conservatives are divided on that issue. And I have some fine conservative friends who are for it. Personally, I think it's a very dangerous thing. I think the result of this, first of all, in fact, they've even changed their tone. They used to say this could be limited to 1 amendment or 1 amendment only. Well, that's not even what the Constitution says. It says for the purpose of considering amendments, plural. Secondly, they're calling this a convention of states, which it is not. The phrase convention of states is found nowhere in the Constitution. All the states do is apply for a convention. When they apply for it, then if you read Article 5, Congress shall call the convention, meaning Congress, not the states, will make the rules as to what the convention is going to do. No guarantee that it will even follow those rules. There is no limit to what they might do. And anyway, I think it would be a very dangerous thing, and I just put it this way, that a new convention, given the mood of the country today, would be, if it's not constitutional suicide, it's at the very least constitutional Russian roulette. And the other is, those who are calling for this seem to have the assumption that a new convention would be made up of people who think like those of us in this room. There's no guarantee of that. It could very well be made up of people who think very differently from us. So again, I think it could be dangerous. Now, as to the ERA, Tammy's talking there about the Equal Rights Amendment, or so-called, that was proposed back in, I believe, the 1960s, and Phyllis Schlafly led the drive against it, and it never got the necessary states to be ratified. They even tried to extend the ratification period, which I don't think they had the authority to do, but the court never ruled on whether they could, because they couldn't get the necessary 38 states, even in the new period. And now they're saying we can propose it again. And they're saying that it can come up for discussion again, and states can now, and Illinois has ratified it again. I personally think that when Congress, here's maybe a point I should make, is that what does the Constitution say? When an amendment is adopted, how many years does it take for it to be ratified? States have to, 3/4 of the states have to ratify it within what time limit according to the Constitution? Anybody know? A lot of people will say 7 years, but the Constitution doesn't say. In fact, with the Bill of Rights, they never specify the exact period. But commonly, when Congress passes an amendment and says it to the states, they set a time limit, and commonly that time limit has been 7 years. That's what they set on ERA. Then they tried to extend it before the 7 years was ended. They didn't meet that, and so either at the end of the 7 years or at the very least at the end of the 14 years it was dead. Now they're trying to resurrect it again. I don't think they have a legal basis for doing so, but I think it shows their desperation. And That may not be the only reason they want to do it, but it certainly is one of the important reasons, the abortion reason.
Thank you.
Are there others? Go ahead.
If a person would commit murder and murder a woman who's pregnant, they're charged with 2 murders. So that has to speak a lot, you know.
Again, that'll depend on state law. But if that has been before the courts before, and if your state law provides that there can be 2 charges of murder in a situation like that, where a man kills a pregnant woman, then the person can be charged with 2 murders. The law has to provide for that. But if it does, then there will be 2 charges, and the courts have said, yes, that can be done. You're right. I don't know about Iowa for sure on that. I know we have that in Alabama. Question?
No, quick question, just, you know, if you guys are interested while we're here, like, as you listen to good ideas, doesn't it spark other good ideas? That's kind of like a meeting of the minds. So how do you feel